Yes, hi. Thank you for having me on the show today.
Thank you for being my guest. During our planning meeting, we were talking a little bit about what you do. I was like absolutely amazed at how much goes into your business.
Absolutely. There's many different components to the intellectual property world. And
how much you have to know. Like, how many years have you been doing this?
I've been doing this since 2008. That's when I passed the registration examination for the patent bar. And then I opened up a company called Inventions International, Inc. And that was a platform for me to be able to provide, my services to different individuals and corporate entities and helping them achieve the protection they needed for their intellectual properties.
And you have a bachelor's degree of science in biomedical sciences from USF. You've spent many, many years seeking out leading entrepreneurs worldwide, and I have a feeling you're just a mover and a shaker.
Yes, absolutely. What happened was I was studying pre-med at USF and obtained my bachelor's degree in biomedical sciences there and was intending to become a surgeon. Well, then I met my husband, and my husband's an inventor. And he somehow, my life changed from there because I switched from medicine to inventions. But I'm able to take that pre-med background and really hone in and focus on medical and dental innovations. And so that's helped me out there. But in order to become a registered patent agent by the United States Patent and Trademark Office, one of the requirements is that you have to have a technical background, either in the field of engineering or science. So me having the bachelor's of science qualified me to take the registration examination for the patent bar.
Now, what type of a surgeon were you going to be? What did you originally set off to do? What did you think?
I really wanted to be a plastic surgeon. And, I understand it takes a lot of dedication and time and everything. And, I ended up, turning my life around into patent law and having kids, and I know that it's just a lot harder to do that in the medical field. But
sometimes you just never know. Like, you think you're going to go down one path and you just don't end up in that direction. I know what I do is not at all what my degree is in.
Yeah, absolutely.
So, I guess where you first sort of experimented with this was when you met your husband before you were married. He's an inventor.
Yeah, so he really got me involved in patents. Usually when you meet somebody and you're dating, you talk about, hi, how are you? What do you, how are you dressed today? With this and that, little fluff things. But really, when I would call him on the phone, I'd be like, how's your day? And he'd be like, man, I'm in a litigation against, these big companies for patent infringement. And, I was hearing that not just, once or twice, but I heard it every day, hour after hour, year after year, about all of these patent litigation problems and how he's had to overcome all those hurdles. And, really.
So either you really liked him, you were really interested in what he had to say, or both.
I know. I mean, it was more of a glorified internship, if to look at it at best, okay? But it's really helped me out in the field of work that I'm in, because I'm able to, take those mistakes and those flaws that previous patent attorneys had done to my husband's patents, and I'm able to learn through those mistakes, and we're not making those mistakes again, because those mistakes are $1 million mistakes, and especially if you're spending $100,000 on an expert testimony fees. I mean,
right.
The litigation for patent enforcement is very expensive.
So back up a little bit and explain, like, what is a patent for the person listening?
Sure.
Because I would really love to break this down in the most simplistic form. So for you, you're like so advanced, so you know so many things that go into this. But if you back it up to the simplest form, you have people like your husband that fix a problem or have an idea.
Yeah, exactly. So it basically comes down to regular people like you and me, and they come across a problem in their everyday life. For example, my husband, we bought an underwater fish light, and it was a halogen bulb encased in a lens and a housing. Okay, it's a simple fish light. So we used it, and it kept leaking. It kept leaking, and then we'd have to get another one. Or it kept shorting out. The bulb wouldn't work. And, he just got sick of it. So he's like, you know what? I'm just going to go and make improvements myself. I'm going to invent, the underwater fish light with internal cooling system. That way it cools the lights, and that way it doesn't short out. I'm going to create the underwater fish light with an improved ceiling structure so it doesn't leak anymore. So it's really people taking it into their own hands to make improvements on problems that they overcome in their everyday lives, and also people recognizing the long felt unfulfilled need for something, and they go and they develop it themselves. Now,
are you finding that most of the time people are just like the brains, the idea behind it, and then they have to find someone else to basically implement it or do a prototype or something like that? Or do you see a lot of people that sort of do a little bit of both?
You know, it really depends on how technical that individual person is and what their background is in. Now, I'm more than willing to take somebody's rough idea and help them convert that into an invention to where they're able to teach somebody how to make and use it. Like, for instance, you know, a flying carpet. Somebody says, hey, that'd be a great idea if I invented a flying carpet. Well, it comes down to, how do you make that carpet fly? What are the structural components that make that carpet fly? You know, I can do my best with my background to help you out, but you know, it comes down to the inventor. The inventor is supposed to be disclosing to the general public how to make and use their invention. And that's really what a patent is. It's the intellectual property right granted by the United States government to an inventor to exclude others from making, using, selling, importing into the United States, and offering for sale within the United States their claimed invention.
So to even get to that place, the idea has to be something that you can teach someone, and they have to be able to teach them how to make it and use it, correct? Exactly.
You need to know the structural components on how to make it, not just in a functional way. So, for instance, the underwater fish light invention that my husband invented, we would have to teach, okay, there's an internal cooling system, there's a chamber with 4 walls, there's an opening which allows water to flow through, and so you really have to talk about all the structural components. Now, if a client is not able to provide all those details, I can certainly, I've done magic, looking at a paper napkin with some notes on it and converting that into an enforceable patent.
So ask them enough questions to kind of get the process started.
Yeah, absolutely. And you don't need to have a prototype. All you need is your inventor's notes, and you need to have if you do some hand drawings or sketches that would help aid in the clarification of your structural components, that would be great if I had that as well. Now, a lot of people that contact me, they often conduct a little search of their own to see if their invention has been patented already. Often they utilize Google or Yahoo or on the internet, and that's great. So if you find something that's very similar to what you'd like to patent, you want to bring that in and have me take a look at it. And it's not a game changer if you find something very similar, because all you need is one novel feature to overcome any prior art references.
Because sometimes it's a matter of making, like, there might be, you use the example of a bucket, but then you do something very specific about that bucket to make it better or more usable or different.
Right, yeah. I mean, if you want to add the handle to the bucket. So that handle is a novel feature that is not taught in the prior art. And then from there, if you want to make an improvement on existing technology, such as the bucket example, if you want to add a spigot to the bucket, so then that's an additional feature. So then that's how an invention is patented. One thing that happened March 16th, 2013, is the patent laws changed. Obama converted the Manual of Patent Examination Procedure to include the first to file provision, which means that if you have an invention, it's whoever files for a patent application and submits it to the patent office to establish their filing date, whoever does that first is entitled to the patent rights for that.
And that's the perfect time for us to segue into our next break, because when we come back, we're going to talk about the different types of patent applications, because there are different types offered, how you can expedite that process, and so many more things you need to know. Studio calling lines are 727-441-3000. We have Tiffany Miller in today with Inventions International. I'm your host, Katrina Maidwell. We'll be back in just a minute. Stick around.
It'll fly by like that. We're trying to fit it all in.
I know. So I made a little timeline of everything I need to talk about. So we're right about here. So I'm trying to keep it on track.
We'll get there, and if we need to skip our last break too, we can.
Just wanted to make sure you know how to reach us on our off-air number.
Hey, Chris. Can you hear me? She's got a lot of content, so we may have to blow through our third break and just do 3 segments.
Yeah, there's a lot. And I came across some of the articles that I had on my website, just some really important topics that I actually made articles of.
Awesome.
So I can help brush in on those too.
I was going to ask too, the one thing that I always think about with patents is a lot of people don't want to get patents, because once you do, the invention becomes part of the knowledge, and then anybody can come and just tweak it a tiny bit and make it better, and now your idea is junk, basically, right?
Well, some of the stuff she's going to cover.
Yeah, I'll be covering it.
That's why I want to know, because there's a lot of things I think about, and I'm like, I've been hesitant, and a lot of people I know who have ideas are hesitant to get them.
I'll make sure I talk about that.
Because they're like, well, as soon as I get a patent, then all of a sudden it's public knowledge and anybody can steal it.
Okay.
I know we're going to probably close to the bottom of the hour.
But
We should be close to that
we
topic.
can hit the bottom of the hour and then just go the rest of the way.
Yeah. I'm saying you can specifically ask that if you want.
So should I save that for when you ask?
Probably.
Because I have a whole thing where I'll be talking about that, but you can ask.
Yeah.
Okay. Do you want me to ask it when we come back here, or do you want me to wait until after?
We're still a
Maybe
little
wait a
ahead.
little bit. Yeah, wait a little bit. Yeah.
We'll do it in the second half.
Yeah, definitely after the bottom.
Yeah, I can talk on and on. Oh, perfect. Okay, great. Very nice. Right.
And it'll be on a podcast too, so if you want to like read your idea. Huh?
Should I put these back on?
Yeah, we're gonna start in a minute.
Okay.
And you know,
Oh my
Katrina,
gosh.
your reference to visit Tampon Talk to get to the website, right?
Yeah.
Specialists who are here to serve you. Visit TampaHomeTalk.com under Radio Show for all of our contact details. MNLS 109600 is an equal opportunity and providing children residential.
I think I want to start off by saying what can be patented and specifically go into like that.
Sounds good.
That way they know.
Talk about what and segue into how. Welcome back. You're listening to Tampa Home Talk. I'm your host, Katrina Maidwell. In studio today, we have Tiffany Miller with Inventions International Incorporated. Amazing wealth of knowledge here, talking all about patents. If you missed the earlier part of the show, or you want to get in touch with Tiffany, hop on over to TampaHomeTalk.com, and you'll find all of Tiffany's contact information, website, phone number, where you can ask her some questions. We're also live in studio, 727-441-3000. Again, 727-441-3000. So what kind of things can even be patented?
Okay. Right, yeah. What can be patented? Any useful process, machine, manufacture, or composition of matter, or any improvements thereon. So if you have a something that is more structural, you can patent a structural widget. Or if there's software, you can certainly patent software applications. And I know that since technology is a big thing right now, and the apps on the iPhones are huge. So, you know, recently I've been getting more and more clients that are more honed in on these software apps. And
that would make sense because it takes a lot to even get it submitted to get it approved.
Yeah, there's a lot that goes into the patent application process. Now, the patent application process consists of two portions, the drafting portion and the prosecution. The drafting portion, even before you get to the drafting portion, you may or may not choose to conduct a preliminary search on your own or have a professional search conducted by myself, registered patent agent.
Which is going to be a lot more detailed than something.
Which is going to be extremely more detailed because we're looking at any issued patents or any published patent applications either in the United States or internationally that could bar you from obtaining patent protection. Now, the first step to the patent application process is coming in for your initial consultation and really discussing those structural components of your invention with me. I need to know how to make and use your invention. I need to know how your invention could have any alternate embodiments. If there's other ways that you're thinking in the back of your mind that you could make and use it, even if you don't intend on making and using it that way. I do have an invention disclosure form for all clients to fill out that will help guide them and to get all of their thoughts focused in on paper, and then they can send that back to me prior to a consultation. I can review it. That way I'm more prepared to really discuss those fine details with them.
Well, there was one little thing you mentioned a minute ago about thinking about the different ways you could do it so you could also encompass those things into the patent, correct?
Yeah, it's really important to talk about as much as you can in that patent application. You know, when I'm drafting these patent applications, there's three main things to think about. There's the inventor's invention, and that's, you know, that makes the inventor happy. You got to talk about what they want. You also have to anticipate how a competitor could come in and add some small features to try to get around your patent and not have to pay you royalties down the road during infringement. Because what's going to end up happening is any competitor is going to, once your patent issues into a full patent, a competitor could come along and they're going to try to invalidate your patent by saying, hey, I don't have this feature. I have feature A, and you don't teach feature A. Therefore, I'm not infringing. I don't owe you any royalties. So it's really important.
Even though the bulk of the idea might have been that inventor's.
Exactly, because, you know, all it takes is one novel feature to obtain a patentable invention, to get an issued patent. So, you know, one novel feature to overcome any prior art, and that also includes a competitor. You know, so if a competitor adds a feature, so when let's, you know, for instance, use the bucket example, you don't want to claim a round cylindrical bucket because a competitor is going to say, hey, my bucket's triangular shaped. My bucket is square shaped. I don't infringe. You know, my bucket has a curve, so you have to be very careful when you're drafting these claim limitations. You need to very broadly draft your specification, and to also not only anticipate future competitors' enforcement, infringement challenges, but
so
also,
they basically don't rip off your idea.
Exactly, exactly. So you always want to keep that in the back of your mind. You also need to anticipate the examiner's office action responses, because when this patent application is submitted over to the patent office, and we do utilize the electronic filing system, which allows us to electronically submit the specification, all of the accompanied patent drawings, the claims, the abstract, that once you press submit, you have your patent pending status, you have your application serial number, so you're patent pending.
And it can't be really modified by that point, right?
Yeah, by that point, if you want to make any amendments, any additions, it cannot be a new matter. Otherwise, you would have a new filing date when the new matter was submitted. So that's why it's really important to talk about everything right before you file that application, because you can't make any changes. If you do make changes, it would be a continuation in part, and it would have a filing date for when you submit that continuation in part application.
Which has to do with that Obama thing that was changed.
Well, first to file. I mean, it's very important because, you know, everything that's disclosed to a registered patent attorney, because they've taken an oath before the United States Patent and Trademark Office, there's attorney-client privilege. So I cannot disclose that invention to a third party. Now, if you're an inventor and you disclose that invention to anybody else, your friend, maybe a marketing firm, or another invention firm that might not have legal representatives that are registered with the United States Patent and Trademark Office, there's no attorney-client privilege, and they could easily disclose that invention to a third party. And if they file for a patent on that same invention as you before you do, then you no longer have those patent rights. And in order to challenge that, it would cost you tens of thousands of dollars to prove otherwise.
That's kind of what you were asking, Chris, wasn't it?
Well, people really don't understand how a patent works. And what a patent does is it prevents others from making, using, selling, importing into the United States, or offering to sell within the United States your claimed invention. So of course, once your patent application issues as a patent, you very well might have a competitor. You might find it on a store shelf, and you're thinking to yourself, hey, they're using my invention without my knowledge. I'm not collecting a royalty for it. That's when you have to enforce your patent. And there's many different ways to go about enforcing the patent. One of which is called a patent troll, and it's a holding company that will enforce the patent for you. And
guys just kind of sit around and wait for someone to try to rip off and duplicate your idea.
Yeah, and what's interesting is that the patent trolls will find an invention that is currently being made and used by others, and they'll go and end up suing them for patent infringement. And so that's how you collect royalties and damages.
It's all in the details, which is definitely, I can tell by talking to you, is where your knowledge, your vast knowledge would be so beneficial for the person listening that wants to do a patent. We have to take a quick break. We're at the bottom of the hour. When we come back in a minute, we are going to go back into what the patent process is and how we can get it expedited, how long it takes, and more. We'll be back in a minute.
Yeah, you could do like 3 segments. You could do 3 segments with Tiffany.
Yeah, we're gonna have to, because we should then too.
With these, this is one of the articles that I wrote on the patent trolls, and it was, the patent trolls are designed to really help people that have they have the invention. Like say it's a mom and pop that have their invention. It's not a big corporate entity that has a lot of money to enforce it. Maybe notice someone's using it, so then the patent trolls come along and say, hey, stop using mom and pop's invention. You got to pay, or you got to pay them a royalty to use it. So there's nothing wrong. It's actually helpful. But this is actually from the White House Office of the Press Secretary, and Obama states that the patent trolls don't produce anything themselves, and they essentially leverage and hijack someone else's idea and see if they can extort some money out of them. Like that was a big thing that, even the president's kind of ignorant to what's really going on. He thinks that, oh, they're hijacking. They're not. They're helping, people that can't afford it. So I don't know if that's something that I should, talk
Why not
about.
touch on that? I mean, it's right up the line. It's not too far from what Chris asked.
Okay. So that's okay. So then we need to go and talk about finish talking about the patent process. I talked about the initial consultation, and so now I need to talk about the different parts of the patent. Yes.
Yeah.
Because I know I guess we skipped around some.
Well, the application, then what goes into it? People are going to want to know how long.
Okay, so yeah, I'll talk about how long it takes for me to draft the patent application. And then we'll talk about, I haven't even talked about the prosecution yet.
Okay.
And then we'll talk about, actually with the Obama thing, I'll save that for the end with licensing and assignments.
Okay. It sounds like it fits in nicely together. That should be good. Thank you for the pen.
Yeah, you're welcome. It has a little flashlight.
Oh,
On the end of
really?
it.
Oh, I've gotten one of these before. I love these. Oh, okay, the thing's in there.
It's like, yeah. Did you get one too?
I'll have to hide it from my kids. So like,
Welcome back. You're listening to Tampa Hen Talk. I'm your host, Katrina Mangwell, and in studio today we have Tiffany Miller with Inventions International, talking all about patents and what goes into this extraordinary, complex process. So where we left off, we really didn't even get into the application part yet. So just hop right in, Tiffany.
Okay, sure. There's 3 different types of patent applications that you can apply for. The first is the most common. It's the utility patent, and that protects the structural components of your invention, how it's actually put together from a structural standpoint. A utility patent is enforceable for 20 years from its filing date. So for that 20-year time period, you're able to prevent others from making, using, selling, importing into the United States your invention. There's also design patents, which protect surface ornamentation applied to existing articles of manufacture.
So what's an example of that?
An example of that is if you were to take a smiley face or a picture and apply it to a backpack, or if you were, so a backpack is an example of an current article of manufacture. It exists. You're not inventing a backpack. You just want to put a decoration on it. So surface ornamentation, if you're applying any kind of design to it. Also, I noticed that makeup companies have, for instance, a mascara bottle. Some of them, if you go to the store, they're all shaped differently. That's protected under design patent. Also, cowboy hats are the specific shape of a cowboy hat. Those are some examples, and those are enforceable for 14 years from your filing date. There's also plant patents as well. Those are not as popular. Mostly, it's more the utility patents and the design patents.
What's an example of a plant patent?
If, for instance, the soybeans, the Monsanto, I don't know if you've heard of that, but the soybeans were genetically modified, and the seeds were flying onto, and it was patented, and then the seeds blew over into another farmer's land, and obviously it was growing the genetically modified soybeans. So the Monsanto company was, enforcing their patent and ended up suing a lot of these farmers for the infringement of using their genetically modified soybean.
Wow.
And even though, it's still, patent infringement, even though you don't know that you're infringing on someone's patent. And so, it's considered negligence. So you really need to make sure
you're not accidentally doing something. What's an example of utility patent?
Okay, yeah, the utility patent is the most common. So if you want to develop anything that has a structure, if you want to, like the bucket, and you want to add a handle to the bucket, that's a structural component. Maybe it's an arched handle with 2 end portions that connect to the base of the bucket.
So it's a use.
It's a use.
Of some sort.
It's a use, and then it also can be a process or a method. A method of conducting business is the software patents, and a lot of those fall in the electronic.
There's even chemical for medicine.
Yeah, there's pharmaceutical patents, absolutely. So if you have an idea of any type of improvement on an existing, anything. If you're sitting in a chair and you're saying, hey, I can make an improvement on this, or anything. I've had moms with children that come to me and talk about how they wish they had, some super device.
I had a client actually that invented, and I believe he patented the diaper belt, because his son kept taking off the diaper, shrieking, so he put on the diaper belt that he couldn't get the diaper off.
Yeah, that's cute. I hear a lot of stories that are like that, very similar. But yeah, that's certainly something that you can file a patent for. Now, once you have all of your inventor's notes and you you know what you'd like to patent, then what I'm able to do is I'm able to draft a compliant and formal patent application. You will need formal patent drawings to accompany that. So I know that, you know, a lot of times you'll give me the hand drawings and sketches. No worries. We do work with patent drawing engineers that will convert those very rough drawings into very formal patent drawings to accompany the patent application. Usually it takes me, because it's so detailed, usually it takes approximately 6 to 10 weeks for me to draft the patent applications.
How many pages are those, just out of curiosity, when it gets submitted? I'm sure it ranges, but what's a rough estimate?
I mean, if it's a really complex patent with a lot of alternate embodiments and you're talking about a lot of figures, I mean, it could be at least 30 pages. So, you know, a lot of people don't know what's all involved. It's not just a document that you fill out and you sign the bottom.
It's not plug and play by any means.
Yeah, it really needs to be. There's multiple pages in different sections, and you know, you got to talk about your invention. You have to talk about the anticipations of competitors, how they could change it. So you need to talk about all those modifications that you can make. And also, you need to think about the office action responses. So, and we'll be that's part of the patent prosecution process.
So how, before you jump into that, how long does it take? You said roughly 6 to 8 weeks just to put it together and draw it and outline it for submission.
Yeah,
so beginning to end, like from the time somebody meets you with a paper napkin, the idea, to the time it's like, yes, we have the patent.
Okay, so the time period from when they come in for their consultation to when we file the application could be between anywhere 6 to 10 weeks, just from the filing of it. Now, I do offer expedited drafting services to where, you know, I will definitely work with you because there are deadlines. So maybe you have a provisional application, and I know that we didn't really touch on the provisionals too much, but that's a temporary application. It's only good for 12 months. It just reserves your filing date as you develop your invention further, or it's a lower cost alternative to the non-provisional for establishing your filing date. It's only good for 12 months. So a lot.
It gives you an idea to get stuff in order and get that time.
Yeah, absolutely. And so what happens is there's a time frame. So if I have to meet somebody's deadline, I'll get that done. So, but standard in 6 to 10 weeks to get that submitted to the patent office.
But then when you submit it, it's not done. It's the whole process.
It's not done. That's just halfway done. That was the drafting portion. Now it's prosecution. Now once it's been received by the patent office and you have your patent application serial number, you then have a patent pending status. That application needs to be sent over to a contractor that's in the art unit. And the art unit is the general field of invention that you're in. Are you in marine? Are you in automotive? Are you in aviation? Are you in a chemical field? So it gets sent on over to there and they make sure that you filled everything in correctly. It then gets issued over to an examiner. And what happens is that examiner will then conduct a patent search of the issued patent applications and the issued patents over at the patent office. So in a standard procedure to receive at least one office action that was written up by the examiner, and he tells you, hey, I found, you know, patents A, B, and C that are very structurally similar to your invention, and now the burden is on the applicant to then file a response saying, no, we have at least one novel feature that will overcome these prior art office action references, and you know, then you submit that, and that's the first.
So it's usually not submitted, you got approved. Normally it's almost like a counter offer, right? They're coming back saying, no, you got to fix this, this, and this.
Yeah, they just don't pass out issued patents to anybody. You have to actually prove that you have a novel invention and that it's non-obvious, it doesn't anticipate any prior art references. So, and they're very thorough over there. If there's something that's similar, they'll find it. But you know, one thing to keep in mind is even if you conduct a search on your own and you find something very similar, you have to keep in mind all you need is one novel feature that's not shown or talked about, one improvement, and really focus and hone in on that and teach the examiner that you do indeed have that novel feature, and that's how you get an issued patent.
And what's an idea of cost? Because there's some hard costs, right? That just go even just to submitting the application.
Yeah. So what there is there's when you submit a patent application, you have the governmental filing fee, the governmental search fee when the examiner conducts that search, and you have the examination fee. And those are all the governmental fees. And there's different tier brackets for paying those fees. So there's small entity, micro entity, and regular undiscounted fees. So in order for me to determine which entity status you qualify for, you have to fill out the invention disclosure form because the questions can be rather lengthy. But just so you know that there are fees involved in the application process that are unavoidable. You know, the United States government doesn't mess around with that.
Well, they're not work for free. So.
Yeah, absolutely. So, so what will happen is when you submit your patent application to the patent office, it is kept confidential for the first 18 months. It's not disclosed right away to the general public. 18 months from filing, it will become public to the general population.
So public knowledge.
It will definitely become public knowledge, but you will be protected because you do have that filing date. So once your invention becomes allowed and issued by the patent office, it's kind of retroactive, so you can enforce it from your filing date.
Gotcha. So, and then once you get past that point and you even get the patent, what do people do with it at that point? Do they usually sell it, figure out how to market it, and then there's the other whole piece on enforcement?
Right, exactly. So, you know, once your invention is patentable, and by patentable, it means that you have your issued patent. You know, it doesn't necessarily mean that it's enforceable. That means that it needs to be drafted correctly in the correct format, and also it needed to have been drafted in anticipating, you know, those competitors trying to add modifications. So what you would have to do is there's many options on what you can do with your issued patent. You can assign those patent rights to others, and by assignment, I mean you can just sell the property rights and then you know, and then collect whatever sum that you've made from the selling. You could license those rights, and by licensing, I mean you could rent the use of, whether they make it, use it, sell it, import it into the United States. So you could license it and collect the royalty checks, or you could go and manufacture it and make it and sell it and use it yourself.
I would imagine that's probably the most beneficial as far as money, but it's probably the most costly to get going.
Yeah, I mean, if you decide to, you know, it really depends what field you're in. If you're going to need injection molds to make your invention, or if you're going to have to, you know, buy all the equipment, it could be expensive initially. But, you know, at the end of the day, if you don't have an issued patent, you won't be able to prevent others from making, using, and selling it. You won't be able to enforce your invention. So that's why it's really important, if you intend to make money on an invention, you need to have it patented.
So let's talk about, you know, what do you do after you get that patent and someone has infringed it? It's probably a good time to come back to the trolls that you mentioned earlier.
Okay, sure. The patent enforcement companies. So, you know, there's a lot of people that cannot afford the legal attorney fees for enforcing their patent. So what they have is, they call them patent trolls, and they're patent assertion entities. That's their.
So it's like a company that you hire.
Yeah, it's a company that's designed to protect the individuals and business entities from companies that have infringed patents. Now, these companies are hired by just, you know, mom and pops that might not be able to afford the attorney fees for litigation.
They want the protection.
Yeah, and they want the protection, so that the patent trolls will go out and find people that are infringing, and that's the whole point of a patent, is to prevent others from making and using it. So if you see your invention on a store shelf without your permission, of course you have the legal right to enforce it. But if you can't afford it, then you might need to use a patent assertion entity. Well, you know what was interesting, it says it was back in 2013, in an effort to promote the development of technologically advanced patents, the White House had issued 5 executive actions. And according to the White House Office of the Press Secretary, President Obama had stated that these quote unquote patent trolls, quote, don't actually produce anything themselves, and they essentially leverage and hijack somebody else's idea and see if they can extort some money out of them. Now, you know,
which is not really what's going on.
That's not what's going on, and they're not extorting money. They're actually enforcing a patent that somebody has worked very hard at trying to obtain, and that's the whole point of a United States patent, is to protect
intellectual
property and to prevent others from making and using. So when I read this, that the President of the United States didn't even understand the dynamic of that, you know, I was shocked, you know, because he's, you know, part of the government, and the patent office is, you know, in the federal court system. So it's just really surprising. It was just
shocking. I'm sure, shocking. So what happens when you get to that place and you see that someone is perhaps or even intentionally rip off and duplicating, or, you know, using, making, distributing?
Yeah. So then what you need to do is, you need to create a file and really document those, all of those acts that you've noticed others making and using. And then when you do go to enforce that patent, you definitely want to bring that file with you.
And this is all federal. This is not even local.
Yeah, it's in the federal court system. And really it comes down to your claim limitations, because what's going to be happening is that examiner, or the that judge in the federal court system, is going to be looking at your claim limitations word for word. And, you know, during a patent invalidation case, they have a Markman hearing where the judge will determine what each and every word means in your claim limitations. So it's very important that you have made a definition of each and every word in your application when you drafted it.
Which is a lot of the stuff that you do.
Yeah, so it's really important to get it done the first time, really anticipating patent infringement and validity challenges down the road, and really getting that patent application talking about all of the definitions.
So talk about if someone just uses one of these places on the web to patent their thing, and they're definitely, it's a flat fee. They're not putting as much time and effort.
You need to, well, a lot of times whoever's drafting the application isn't registered by the United States Patent and Trademark Office. So you really need to make sure that you find a legal representative that's been registered by the United States Patent and Trademark Office and that has passed the patent bar registration examination. And what you can do is you could take that agent's registration number. My registration number is 63465, and you can actually go to the uspto.gov website and do a patent agent search, type in their registration number, and verify who they are. Mm-hmm. And I think that's really important, is the whole trust issue, because a lot of my clients that I've talked to are scared, are very hesitant to disclose their information. They don't want to talk about it because it's very, it's very important to them. A lot of these clients have been developing their ideas for years, and they just don't want somebody to take that idea and run with it. And so it's, confidentiality is very important to me and to my company.
And I respect that, because I know we were talking, I always love examples and stories, because I think people can relate to that. And I love the fact that you're so protective of that information, that you wouldn't even share stories with me, which is great. And at least your husband is an inventor, so you can talk about that and share those ideas.
He actually has over 50 United States issued patents.
50?
Yeah,
wow.
Over 50 that are issued, and he has many more that are pending, and many more that I'm currently working on.
Wow.
And Senator Marco Rubio had flown a United States flag on his behalf at the Capitol in recognition of his patent accomplishments.
He's one of the politicians I've been following for a while. I think he'll do well wherever he lands, for sure.
Yeah, absolutely.
So I just want to make sure, we had so much stuff to cover, and I want to make sure that we didn't miss anything that was super important. But can we talk about the toner that you're, like, how, because I really want to share, like, the idea of the problem and how this came to light.
Okay, so my husband, well, one of his inventions, and I know that I discussed the underwater fish light with you and that problem and how he solved it and patented it, and now he's manufacturing it. And another example, he's in the toner cartridge industry, and we have a friend here, a local friend, that he owns the coin copy machines in the Publixes and that you see in the stores. And one day he was saying, man, I have to carry around all of these toner cartridges. He had a big truck full of, 20 toner cartridges, one toner cartridge for each printer. And, they were just discussing that problem. And my husband was like, why don't I just make one toner cartridge to fit into all of these different printers? That way, our friend doesn't have to carry around all of these toner cartridges. So he invented the universal toner cartridge with the universal microchip technology, because every toner cartridge needs a microchip to communicate with a printer. So,
which is so fascinating, because I never even thought about this. I mean, I use a printer every day, and I never thought about, when that light pops up and says the toner's low, that's a microchip in there.
I know. And then also on that toner cartridge, he invented the thumb grip. There's one thumb grip, because you used to have to grab the toner cartridge with two hands, and there would be toner cartridge everywhere. But now it's a centered thumb grip in there, and so he invented that.
Wow!
So there's
one novel feature.
Yeah, and there's many different toner cartridge components that he has developed, and that's that shows in all of his issued patents. So, and it's really neat to see how these patents he's actually developed the technology, he's manufacturing it and distributing it, and we see it, and he's enforcing it. So I get to see it from a perspective from how it first started to all the way to litigation, and he's been in high profile litigations with these patents, and he's overcome those all those litigation challenges, and I've learned a lot of knowledge, and you just can't learn that from a book. You can't learn that from
real world hands-on experience.
Yeah, I mean, I was living it. So I'm just fortunate enough to have been exposed to that, and I'm able to provide my clients with exceptional, patent drafting and prosecution services.
So, like, for example, using his example, he came up with this universal toner cartridge that would fit into several different machines. And that would be an example of one patent, but then another patent might be the microchip, and then another patent might be that handle where you can pull with one hand. Is that right?
Yeah, that's correct. And, if you talk about an invention, and you talk about many different ways that you could make and use it, the patent examiner will require you to split up those inventions into separate patents. And so you might end up filing for one patent application and end up having to have several patents off of that, depending on what you've disclosed and what you want to claim. So you never really know until the examiner has looked at it, and I can get a good idea of the claim limitations if it's talking about two distinct inventions, but you can get many inventions out of one idea.
So, and that's amazing to me, really. I mean, never would have even thought about that before today. So beginning to end, this is probably at least a couple-year process? At least,
okay, so yeah, we did talk about the prosecution, how long that takes. Right now, because the United States Patent and Trademark Office is so understaffed and they are backlogged, they're just completely swamped with patent applications coming in at them. Right now, it's taking on upwards of 18 months from your filing date for the examiner to even look at your patent application.
Oh, wow.
18 months. Now,
and they're kicking it back usually with something.
And usually, and then you have an office action, and they give you a shortened statutory time period of 3 months from your mailing date of the office action to respond. So that's another 3 months, and then you have to wait for them to respond back to you. And oftentimes they'll allow the application, or they'll issue another office action.
What's that timeline for them to respond?
Usually they respond within a couple months.
Okay.
I've seen, but
that's 2 years right there.
Yeah, it is, and that's just part of the process. They do offer, the patent office does offer accelerated examination, where they'll tell you you'll get your first response in approximately 3 to 4 months from filing, and so that is significant. Instead of waiting the 18 months. Now there is special, if you're 65 years or older, you are eligible for accelerated examination as well, because or if there's reasons based on health, they'll let you do the accelerated examination. So it is always an option to do that, and depending on your personal needs and your business needs, that very well might be a good fit for you.
And so another reason why someone might do expedited examination would be maybe they leak the idea to someone, or like what other?
Just a lot of times, okay, so, for an example, my husband's underwater fish light, we did accelerated examination because it was important for him business-wise to have that issued patent as soon as possible. So, it just really depends on your business. Also, if, a lot of my clients just don't want to wait.
Okay, I have a feeling anxious, anxiety has a lot to do with that.
You do get anxious, and I do have clients asking me for updates, and you can view the updates on the PAIR system, and it'll tell you an approximate first date of the office action response, the projected office action response.
So how long do your average consultations last when you meet with someone?
When I meet with somebody, it's usually about an hour long, and we discuss their patent goals and the patent process and how it directly pertains to them and their invention.
You are a wealth of knowledge when it comes to inventions and patents. So glad to have you my guest today, Tiffany Miller with Inventions International. Thank you so much. You're listening to Tampa Home Talk. If you missed any part of this wonderful show today with Tiffany, definitely check it out in its entirety, because there's some amazing stuff in here, especially if you have any ideas with regards to patent that you would like to get marked as your own, if you will. We will post this on our website at tampahometalk.com and also on any podcast player. Thanks so much for joining us today. We'll be back same time, same place next week. This week, we're out.